We actually have a call. Dan from Bay County is calling in. Dan, go ahead with your question.
Yeah, thanks for taking my call.
Yes, sir.
Question, you have a piece of property that's posted, no trespassing. Someone goes on it without your knowledge, goes on it and gets hurt. Can you be liable?
Dan, that's a fantastic question. I mean, it really is. I mean, because people oftentimes think that if I put a sign up, no trespassing, or if I put a sign up, beware of dog, does that absolve me from liability? And, you know, in true lawyer fashion, the answer is going to be it depends. Now, I know, Brian, if I put up a no trespassing sign and somebody trespasses, there are still ways that you could be held liable, but it's pretty hard. And what's the difference between somebody that's invited onto your property or somebody that's allowed to be on your property? Say it's a utility worker and they're there to work on the, you know, the cable line or the water line going in, versus a trespasser. I mean, what are the different duties that a landowner owes to those different classifications of people?
Yeah, and technically there's one in the middle called a licensee, but we'll ignore that because it's basically the same thing as a trespasser. So if I invite Les on my property, I got to make sure my property is safe and that anything that's dangerous, I've corrected it or put warning signs out. But if you're trespassing, for a landowner to be held accountable, you have to either do something where you know someone is going to be injured. For instance, I mean, this is a crazy example, but if you have a landmine on your property and a kid walks on it and blows up, that's a terrible example. You know someone's going to get hurt. If the kid's trespassing, in that situation, you can be found liable. And ignoring stand your ground laws, if somebody's walking across your yard and you intentionally hurt them and there's no threat to you, then you can be held responsible. But it's a much higher burden for that person who's injured to pursue somebody if they were trespassing. Most of the time, I mean, in those situations, there's almost nothing we can do because most people aren't intentionally hurting somebody, they're getting hurt in a negligent fashion.
Right.
And if you're trespassing, you do potentially have a claim, but probably not. The defenses are too strong.
Right. I remember when I was in law school back in the mid 90s, I'm dating myself here. I remember cases like this, and they were talking about essentially if you set a trap. You can't set traps. Okay. You can't do something that that will knowingly injure somebody. Just because you don't like somebody cutting through your backyard, you go and you put some nails or something sticking up underneath. You're not supposed to. You can't do that. I do believe that the person that is trespassing, if they are injured, you would have to look at their conduct. You'd also have to look and see, did they have any fault themselves? I mean, did they, go, oh, I'm going to go get on that property and go climb that tree, and then they fall off the tree? Were they comparatively at fault? Even if you're on somebody else's land, if you contribute to your injury, and the way the law works is the defendant will be allowed to say, well, wait a minute, you bear some responsibility in this case, and a jury can decide whether or not you bear a percentage of which. And now with the new laws in Florida, regardless if you are involved in a case and you're claiming negligence on the other side, if you're found to be more at fault than they are, 51% at fault or more, then now you're completely barred. You have no claim whatsoever. It used to be comparative fault in Florida. You could be 95% at fault and you could sue for the 5%, but now if you're more than 51% at fault, you have no recovery.
And yeah, it hasn't really changed too much how we evaluate cases, but if it's clear that, somebody contacts us and there's a lot of fault on them, we used to be able to take the case if somebody else did something wrong, even though there was a contribution. But now, if there is significant comparative fault, then it's harder for us to do anything.
Yeah, the most difficult cases are the he said, she saids.
The red light.
The red light. I had the green light. No, I had the green light, and you have
with no witnesses.
And you have no independent witness, and it's one word against the other. Or the premise liability case where you slip and fall, you trip and fall. Most people, I did defense work before I started doing plaintiff's work, and so I've tried cases on both sides of the bench here. Look, hey, you should have been watching where you're going. That is a really effective argument for a defendant if somebody trips over something that appears to be open and obvious. That's not really what the law says. The law says you're supposed to maintain your premises in a safe condition. You're supposed to warn people of any dangers, and you're supposed to make efforts to correct those hazards so that people don't get hurt. And the duties are separate and independent. the duty to warn, the duty to maintain, and the duty to, what's the third one?
No, just to fix once you're aware
To
of something.
fix,
to
thank
fix.
you. Maintain
So
and
if
fix.
so, we always run in we say slip and fall cases in med mal, but slip and fall cases are some of the toughest cases for us to handle because we have to prove, you know, if it's a big retail store, that they're aware of a dangerous condition.
Right.
So sometimes, you know, if an employee walks by a puddle of water 4 times, that's easy. They are aware of the slipping hazard and they ignored it. But sometimes, you know, if you're a customer in a store, you knock a water bottle over and then another customer 2 minutes later slips on it. In that situation, the grocery store didn't do anything wrong. I mean,
well, it's hard to say they did anything wrong because they didn't have an opportunity to fix it. But that leads to a great point. You know, we talk about when should I contact an attorney. Oftentimes when people are involved in a wreck or they're injured or they've had a tragic loss in their family, a loved one is seriously injured or God forbid killed, the last thing that's on their mind is, oh, I need to call a lawyer. In reality, you know, maybe there's a family friend, maybe there's another family member that might be thinking about things a little bit differently. That's actually when you should call a lawyer, because the last thing you want to be thinking about after you've been injured or you're taking care of a loved one that's been injured is, oh, I need to preserve that video. Oh, I need to send an evidence preservation letter to that retailer so the video that shows me slipping and falling on this substance on the floor doesn't disappear because it'll get recorded over after a week. You know, there's all sorts of things that we do on the front end so that when it is time to make the claim, the evidence has been protected, witnesses have been located, we have the set of facts and evidence that we can work with on the claim versus coming in weeks or months after the fact. It's much, much more difficult to do it then. So yeah, don't feel ashamed or shy about contacting an attorney right afterwards. We actually can really help out, and it usually bodes much better for your case if you get us involved early.